How to keep your exhibits from being objected to in Illinois divorce. How to use requests to admit to keep those exhibits from being objected to. I'm doing a big video series about trial techniques for Illinois family law attorneys and other people who are involved in the Illinois family law system. I'm going to be telling you about how to get your evidence in on the record and how to keep your opponent's evidence and testimony and exhibits out of evidence. But before I do this, I'm going to give you a big cheat code. You do not have to wait for your trial binders in court, hoping that your opponent will stipulate to all the documents you're trying to get in last minute, or nervously waiting for your opponent to bring up some kind of objection while you're trying to fumble through gaining authenticity or foundation or all the other things that are required to get physical exhibits into evidence. Instead of going through all of that, which I've explained in another video, we can just send your opponent a request to admit. There's the proposed exhibits and the asking them in the request to admit, do you agree that these documents are real? Do you agree that these documents are genuine? Let's go through what lets you send out a request to admit. It's Illinois Supreme Court Rule 216B, which says the request for admission of genuineness of documents. A party may serve on any other party a written request for admission of the genuineness of any relevant documents described in the request. Copies of the documents shall be served with the request unless copies have already been furnished. So it's a document saying, see all these documents? Do you agree that these are all real? Please let me know within 28 days. Thank you. When you send out this request to admit, you have to have a super big warning on the outside because it's so tricky. Not tricky really, but like it's so impactful. The rule requires that you, quote, put the following warning in a prominent place on the first page in 12-point or larger bold-faced type. Warning, if you fail to serve the response required by Rule 2116 within 28 days after you are served with this document, all the facts set forth in the request will be deemed true, and all the documents described in the request will be deemed genuine, end quote. So make sure you have that on the front of your request to admit. Your opponent then has to answer the 216 request to admit within 28 days, or all the documents will be deemed genuine by default. This way, you never have to go through all the authentication and foundation in an actual trial. Instead, you can just hand the documents over to the judge and say, here you go. My opponent already admitted that these documents are genuine. I don't need to go through each and every little document establishing why they're genuine, why they're authentic, and how they got here. That's called laying foundation. And typically, a family law judge is going to be thrilled because this is going to cut down on so much time in court, and it's going to focus the court on the real meat, the real facts that issue, not on whether this document was this or this document was that, and how close to a real document this is. Judges want to know what they're looking at, and if both parties agree this is what they're looking at, the judge is happy because then the judge can just focus on the content of the document. Once you end up submitting that to a judge, the judge will end up and goes, and the judge says, okay, it's admitted to. I'm admitting this into evidence without objection. It's very likely that your opponent will just shrug their shoulders and say, well, I guess I admitted to it. And then your evidence will be admitted into the record seamlessly. And then you can refer to those entered exhibits in your closing argument without any fear of the evidence being presumed to be not entirely reliable or not entirely genuine. In addition to the request to admit guaranteeing the admission of a document, you can also ask your opponent to admit to facts. It's a great idea to put all the basics like when the parties were married, how many kids they had, the birthdays of the children, the current schedule the parties are observing, basic finances like income and assets and values. You can even squeeze in a few things that they might not catch. And again, remember, if they don't answer, it's all deemed admitted and it's going into the evidence, and then you can refer to it in your closing argument as though it is God's truth, like it came down on 2 tablets down from Mount Sinai. And what's weird is that Illinois divorces and divorce lawyers, we almost never use these requests to admit. Most practitioners, I think, just believe they're going to settle the case on the eve of trial, so why bother with all these extra preparation steps before trial? Well, filing a request to admit shows that you're not just ready for trial, you're willing to go to trial. And divorce lawyers, we are gladiators. We have to be ready to go to trial. You're not ready for trial unless you've done everything you can to be sure that your documents are getting into evidence. The request to admit is not a silver bullet, however. The documents you're trying to admit may still be inadmissible, even though they're genuine, under the concept of hearsay. Hearsay says that you can't speak to the truth of the matter from an out-of-court statement. And most documents, they were made outside the court. So then you have to have somebody say, well, we made this is what we made. I can guarantee that this is not just real, but it's also my words, because you have the right to cross-examine someone. So hearsay is very important. And the admission of a genuineness of a document does not waive the hearsay requirement, or rather the requirement that there be some exception to hearsay or that hearsay be waived. So be sure you've got a hearsay exception for all the documents your opponent has admitted to the genuineness of. You're not going to be able to get away with just saying, well, they admitted to the genuineness of it. Your opponent can sit in waiting for you to be comfortable, to be smug, handing in that trial binder to the judge, and then say, Those documents, while I admit they're honest, I admit they're genuine, they're also hearsay. They can't just be admitted without someone testifying to not just their genuineness, but to the contents within. You can't have out of court statements introduced for the truth of the matter. So hopefully you'll also have either one of the exceptions, the best one's probably the business records exception, should be able to get all your stuff in. But the truth is, I'd be shocked if your opponent realized that a request to admit doesn't eliminate the hearsay rule as well. But who knows? You might end up against somebody like me who is obsessed with all these rules. So in conclusion, you have nothing to lose by issuing a request to admit. It helps you organize your proposed evidence anyways, and it should also scare the other side into realizing that you're dead serious about going to trial. At trial, you'll be suavely handing in your trial binder to the judge while the other side fumbles through authenticating their exhibits. I have a lot of other trial technique videos coming out, so like and subscribe for more tips, hints, maybe even some people might call them tricks. But really, I want to get these concepts across. You can do a trial. Everybody can. You just have to have your mind completely organized to not only state the facts, the arguments, but also organize those arguments and facts in a way that the court not only can accept, but must accept. In fact, if you want to talk about your Illinois divorce court case, please just give me a call, 773-334-6311. I will call you back within 24 hours and we can talk about the challenges you're facing and some of the strategies that I might be able to suggest for you. Thank you.